Professor Tushnet, would you like to start with just some brief thoughts on where the case is right now, what's going on?
Sure. My name is Rebecca Tushnet. I teach at Harvard, mostly trademark and copyright, and move into design patent over the past few years. So my take on the case owes a huge debt to Sarah Burstein's work, which I consider the best and most scholarly work on the subject. And she says some things that aren't clearly on either side of the current dispute, but I find them pretty persuasive. So in particular, she focuses on the distinction in the history and the early case law between the article of manufacture, which is the language used by the design patent provisions, and machines and compositions of matter, which are other things covered by utility patent laws, as well as articles of manufacture. And she argues that under standard statutory interpretation principles, we should figure out what an article of manufacture is, and it's clearly something distinct from a machine. And again, there's some early cases indicating agreement with that. So her idea is that although this didn't get very well developed because utility patent covered everything, so it wasn't necessarily important in utility patent to distinguish a machine from an article of manufacture, we should understand an article of manufacture as something that's made by people, that has a unitary structure and that's complete in and of itself for use or sale, as long as it isn't also a machine or composition of matter. And the relevant question there would be whether anyone makes, uses, or sells that kind of item separately. So, you know, if there's somebody out there who makes washers, a washer is an article of manufacture. Outer shells are typically the articles of manufacture in this analysis, not an entire, car or other machine. And here, that would imply not the phone. I strongly recommend her recent work on the article of manufacture, both in 1887 and today, especially her description of the temptation that we face to aggregate different design patent claims into a kind of Franken-claim, which may be at issue here. She also suggests, and this is more about your approach to civil procedure, but that in any given case, the question of what the article of manufacture is primarily a legal question to be determined by a judge in a way similar to a Markman hearing. And partially this is a policy recommendation given the positive effect that Markman hearings have had on other aspects of patent litigation. So I don't think I can do better than to point you to her much more extensive work on that if you want more.
Thank you. Charles, I'll let you say that for a second. Howard?
Good morning, and thank you to CCIA for putting this panel together and inviting me. My name is Howard Hogan. I'm an attorney here in Washington, D.C. with the law firm of Gibson, Dunn, and Crutcher, where I co-chair the Fashion, Retail, and Consumer Products Practice Group, which means that I have clients that represent just about anything that's bought or sold, from the tech industry to the fashion industry to the retail industry. And so I have clients on all sides of these kinds of issues. In the Apple versus Samsung case, I filed an amicus brief on behalf of Nike, on behalf of neither Apple nor Samsung, but advocating that the court not undermine the important damages protection built into the Design Patent Act. So having my own biases out of the way, I will say that the decision, I think, took a lot of the legal community by surprise because of the narrowness of it. The Supreme Court clearly chose to coalesce a unanimous court around a very narrow holding, which rejected a proposition I'm not sure the Federal Circuit would have claimed to have advocated, that the design patent statute has a solitary rule that says an article of manufacture must be the complete device as sold. And the Supreme Court held that there was no such unilateral rule. That is, in a nutshell, where they tossed it back to the courts below, which is where the case is pending now. you know, the decision is sort of Solomon-like in that it left neither side particularly happy. The problem with, you know, a Solomon-like decision, baby splitting, is that it is often designed to keep neither side happy. And so now the lower courts are trying to follow the Supreme Court's guidance in devising a test to determine when an article of manufacture is less than the complete product sold. The problem is the statute doesn't provide a lot of guidance, as opposed to something like the Lanham Act, which has a damages statute with an explicit burden shifting paradigm, where, you know, the Lanham Act for trademarks specifically lays out that the burden is on the plaintiff to show the defendant's gross profits, and then the burden shifts to the defendant to show every element of deduction therefrom. The design patent damages statute, in contrast, very explicitly says that the plaintiff is entitled to total profits on the article of manufacture for the purpose of sale to which the infringing design has been applied. And so now there are, I think, in addition to Apple versus Samsung, at least 2 other cases where courts are currently wrestling with the issues that we are discussing here today. How do you determine what the article of manufacture is, and who should have the burden in proving damages? And I think I will stop there and let the rest of my colleagues take over.
So I'm Carl Cecere, and I've represented a coalition of minority and rural interest groups in this case. And if those sound like an odd fit for a case involving 2 of the largest companies in the world and design patents, which are a pretty obscure aspect of intellectual property law, that I'd like to dissuade that a little bit, because I think my clients were pretty forward-thinking in getting involved in this case, and we've been involved doing amicus work since this case was before the Federal Circuit the first time. It's because they recognize that this case and the potential for weaponizing design patent damages that it represents is a real threat for competition generally, innovation generally, and because they recognize that the path forward for minority groups and rural people is intertwined with that development of innovation in the country. And I say weaponizing design patents because we're talking at the end of the day about a claim by Apple for 3 design patents that cover not the whole of the iPhone design, not even the whole, for example, of the screen design, but just aspects of the design of the exterior of the phone. And they claim a right to get the entirety of the profits that Samsung earned on several different iPhone models, resulting from these 3 patents on little pieces of the phone that don't cover any of what that phone actually does. And so it really tests the boundaries of what design patents are designed to do. And while it's clear that, you know, Section 289, which gives us this remedy, serves an important purpose, there's a real risk in this case that you can potentially get total profits and use it toward untoward ends. Not only could a competitor who's able to afford to patent all of their designs, they can afford, they can kind of carve out a space that they can prevent anyone from entering their market by aggressively taking those design patents and using them against less established competitors. And they can especially use the fact that the standard for design patent infringement is sort of in the eye of the beholder. Like, basically, at the end of the day, they ask the jury to decide, hey, do these things, does this drawing on the design patent, does it look like the actual article? And that there's a potential there to really aggressively put that forward and scare away people even with substantially different designs. So there's a real risk that you can take that potential to lose all of your profits out of that. And so my clients have been interested in this case to get involved with fashioning the test for determining the article of manufacture in light of the way that design patents have to be used in the real world. Because say you are a person who, you're trying to create a company and you see that there's a design patent, or you see that there's a very aggressive design patent assertion entity, whether they a troll or a company that produces a product, and you have to make real world decisions about how you're going to develop your product in light of that, especially because there's a threat somewhere in there that you could lose all of your profits. So we're interested in this case, and we think that this is a really crucial juncture of the case, because now that the Supreme Court's gotten rid of a bad rule from the Federal Circuit, we've got to create a good rule for what an article of manufacture ought to be. And what our clients are looking for in this, in fashioning a test, is number one, a set of clear rules that people can use to look at a design patent, see what it covers, and make real-world decisions about their legal exposure. If there is an aggressive entity in their space, can they create a product without risk of losing all their profits? If there is a design that, let's say I want to create an app, or I want to create a phone, and function dictates a lot about the way the design has got to look. What are the risks I face if the corner of my product looks too much like the corner of that product, when at the end of the day it's all in the eye of the jury? So we're looking for a set of clear rules, and we think that that creates a real problem with Apple's proposed test, because that is quite clearly designed to try and capture the profits that they got in their first award and design any sort of test that they can possibly get that would give them those profits. But in doing so, it's entirely squishy. Let me just give you a few of the factors that we're talking about. How the defendant sells the asserted article of manufacture. So then now, whether or not I lose all of my profits turns on whether I sell it separately, sell the thing covered by the design patent separately, or whether I do it entirely, and even how I account for those things internally. Like on my own books, do I account for the profits of this thing separately, or do I just keep profits for the phone or the article, the entire product? Then there's also the visual contribution of the patented design to the product as a whole, which is something that is ultimately something that only can be evaluated in the eye of the jury when they look at the product at the end of the day, and is entirely subjective. So when I'm looking at a design patent and I'm looking at my product, I have no way of knowing whether or not it's going to be subjected to a total profits award. And that's not to say that, I'm not talking about people who are going to deliberately copy, or who are out to make it just different enough. I'm saying if you're designing an app and your icon can only be this big, you got to be really, really careful about how you design it in light of this really vague standard. And as any designer will tell you, when I designed that cup holder, I was really careful, and it all flows together. The whole dashboard fits together, and it fits with the lines and the whole thing. So my cup holder contributes to the end-all design of my boat. So when you infringed on the design patent that covered just the cup holder, clearly I should get the profits on the entire boat. And that's an absurd result. But the arguments like that can be made, because design is something that it all flows together, and you can make a good case that everything contributes to the whole. And there are subjective, I don't want to go through them exhaustively, but there's a subjectivity throughout there, throughout Apple's proposed test. And it's completely absent in, I think, the better test that Samsung offers, which is pretty darn simple. You look at the patent. The patent, by the way, for a design patent will have a design, like there'll be a design drawing in it. You can see what it's meant to cover, and when a design patent doesn't cover certain aspects of a product, they're going to designate it with dotted lines. So, it might cover, for instance, the patents here. Some of them cover the front screen, they cover the bezel, but they don't claim to cover the entire phone. So from what the patent looks like, you can compare it to an end product and say, well, what does it cover? And even if it covers only a portion of the article, for example, if it just covers the curve of the screen or the curve of the bezel, well, maybe you get the entirety of the front face, of the screen of the phone, because that's the article to which it's attached, but you don't get the entire phone. You certainly don't get the profits derived from the function of the phone, because as beautiful as an iPhone might be, no one would buy an iPhone if it didn't make phone calls and connect to the internet. It's not purely the design of the exterior that drives the profits of the phone. We have one other important perspective in this case, and that is there is this business, and I've alluded to it already, of partial claiming. That is, you can claim just a curve, just a bezel, and not the entirety of a product. And when you do that, the designer is ultimately in the driver's seat about what their design patent is meant to cover. And I think that determining the test for the article of manufacture has got to take that into account. That is, if they claim less than the whole, then they're sort of saying, we think that these are functionally severable pieces of the phone. We think that this covers only this. And so at the maximum, you should only get the article to which it's attached. You can't, when you partially claim, you're hard pressed to get the entirety of the article of the phone, of the product. And that's another problem with Apple's test, because at the end of the day, Apple sort of derived its test from a test that the Solicitor General offered at the Supreme Court, because they were trying to advocate for the Supreme Court to go ahead and adopt a test for what an article of manufacture was, and in Solomon-esque fashion, the Supreme Court decided not to do that. But they omit the most important aspect of what the government's test was. And that was the first factor that the government said was, what is the designer claiming in their patent? And whether or not you agree with the other factors, that is a necessary element of any test for determining what the article of manufacture is. Because if it ultimately puts the coverage in the hands of the designer. If they really want to claim a design patent on the entirety of the phone design, or a shoe design, if they really want to claim that, and they think that their design is distinctive enough that they can get a patent on that, then they should do that. But when they do less than that, that raises the possibility that they're going to get multiple awards for the same exact thing. It's no accident that in this case, you've got 3 different design patents that all cover aspects of the front face of the phone, the exterior screen, the bezel, and then the 16 icon array. And so Apple's serious contention in this case is that they can get triple our total profit, because on that Samsung's total profit on that whole phone, because they can get it 3 different ways. And that just is not a result that makes any sense in the real world.
Thanks. Charles?
Hi, I am Charles. My apologies for being a bit late. It turns out that when you commute by bicycle, rain actually affects you. So I am the director of the Patent Reform Project at Public Knowledge. Public Knowledge is a consumer advocacy organization where we look at technology policy issues, including patent issues, which is my area of specialty. So I came in a bit late, so I'll just provide a couple of quick reactions to the things I've heard. I think starting with Carl's comments, this reflects something that's been really a big issue for public knowledge and for me, and that's that patents affect a lot of people. I think there's a temptation to think that patents are sort of this weird, obscure area that technology companies and pharmaceutical companies are very involved in, but who else has to worry about it? It turns out that when you look at some of the patents that are coming out there, you've got phone patents. Everybody has phone. You've got patents on tractors. If there's anybody that embodies American individualism, it's farmers, and yet they're stuck dealing with intellectual property. You have a lot of these sorts of examples of patents really starting to affect much more general consumer level things. And I think that's a reflection of how important technology has become to individuals. But at the same time, it does mean that the problems with intellectual property and patents in particular that we once thought were kind of confined to fairly large companies no longer are so confined. And it is worth starting to look at them from the perspectives of, individual consumer groups or groups representing particular consumer constituencies and so on. So, a second thing that I think is interesting is the relationship between the Federal Circuit and the Supreme Court that is becoming evident through the Apple-Samsung case and through a number of other cases. The Federal Circuit seems to really like issuing rules. The Supreme Court generally does not seem to like the Federal Circuit's rules. And this has just been kind of a tradition at this point with regard to the interaction between the Federal Circuit and the court and the Supreme Court. And I think it's worth starting to think, is there a systemic reason for this? It seems unlikely that it's just because the Federal Circuit just keeps making mistakes, because there seems to be a plan, and it seems that the plan is to create that the Federal Circuit views patent law as something that ought to be made up of strict rules that are based on fairly simple principles, and the Supreme Court goes back to more foundational concepts that tend to embody flexibility. And the reason that this is coming up, I think, goes to some of the things that Rebecca was saying about the historical role of patent law. So Sarah Bernstein has written this great article about kind of the history of the article of manufacture. In quite a few cases now, the Supreme Court has gone back to the historical sources to look to how they should interpret patent law. Lexmark, the Impression versus Lexmark case is probably the best example of this, where the cases that the Supreme Court were citing were predominantly from the from the late 1800s, early 1900s. The TC Heartland case relied primarily on a decision from, I think, the 1960s, which was that decision being based on another decision, I think from like the early 1900s, I'm not exactly sure when. The Supreme Court seems to be very interested in these early sources. So, why are those early sources good? And my answer to that, at least, would be that at least the early patent cases, those ones from the 1800s to early 1900s, tended to focus on the ultimate purpose of patents, which is embodied in the Constitution, which says that patents need to be granted with the explicit purpose of promoting the progress of science and useful arts. The courts in the early courts took that very seriously, and to the extent that patent law did not serve that purpose, they were willing and often did revise patent law or adjust holdings to make sure that comported with that. I think that the decisions on obviousness are probably one of the most clear areas. There's a certain sense in which I think we've lost that perspective. In going toward a world of patent law being just about rules, we've forgotten that there's an important value that stands behind the patent system, which is that we ultimately need to benefit the entire public with the disclosure of new inventions, but ultimately with advancement of the public's ability to access technology. And I think that that's a really important perspective that the Supreme Court has been more and more trying to incorporate into patent law, and that's in all of the ways that we look at these sorts of issues, we have to be looking from that sort of first principles perspective of how are we making sure that ultimately it's the public who's benefiting from the patent system and not just a couple of people who hold patents and who are being enriched by it. I think in terms of this case, that'll be a useful framework for analyzing some of the questions that we're going to talk about, but I will turn it back over to Josh so we can get into some of those issues.
I think I'll start by following up on a point that both Charles and Carl referred to, which is that the purpose of a design patent's claim of the drawing is to serve as notice to the public of, here's what I've patented. One of the issues I see with Apple's test is that they're talking about the visual contribution of the design to the product as a whole, and that's something that should be resolved by a jury. They're talking about how severable it is from the product as a whole. It's something that should be decided by the jury. Is it reasonable to think that notice is actually served when you have all of these sort of post hoc determinations being made by a jury with respect to not just the design itself, but the product as a whole, how it's being used, and even the defendant's intentions. One of the points that Apple thinks should be included is that if you're trying to copy a full design, a design as a whole, not the claim itself, but the design as a whole, that should be accounted for. But that has nothing to do with what you originally claimed and what the public knows has been patented. Does the test that Apple's putting forward really comply with this sort of public notice aspect of patents? And I don't know if you want to start, Carl.
Well, I mean, I've sort of hinted on my views about this. It seems like that public notice function is vitally important, and it is meant to do two different things at the same time. When you put out your patented design, not only are you declaring to the world what you're claiming as your property that nobody else gets to use, but you're also saying, this is my contribution to the field of design. Use it in a weird way, because that's what patents do. Patents are both meant to be inventions that we get to make use of, and to build upon to do our own designs, and also to protect the property. So there's a kind of duality in there, and I think that's that's an important function of what patents do. But we got to be very cognizant when we craft the legal rules and interpreting how those patents are to be used, of the fact that notice function is front and center. That is, this is what I'm claiming, this is my property. Nothing else is my property. So why should I be getting a bunch of other things? And, just to kind of give a little bit more framework, the Supreme Court set forth a kind of a two-factor test in the Samsung decision. It said, first, we're going to identify what the article of manufacture is, because that's what you get the total profits on. And then you're going to determine in the second step, you go to see, well, what portion of the total profits, if it's a component of a larger product, if the patent design is smaller, then what portion of the total profit goes to that? And I think that, yes, to make it totally subjective, to make it totally in the eye of the beholder, doesn't satisfy the public notice function, but it also confuses the two aspects of that test. Because when you're talking about the contribution to the whole, you're talking about really what's going into the second aspect. What role does this part of the product play in the entirety of the product, and how much profit should I get because of it? That really goes into the second aspect of the test, if that makes sense. So it's kind of melding of factors, and I think that confusion is problematic in a number of respects.
Rebecca?
So I want to emphasize, I think, that Apple's premise for the argument about this has clear support in the case law, right? So the article described or illustrated in the patent does not limit the infringing defendant, the article that the infringing defendant is applying the patented design to. From that, Apple concludes that you shouldn't look at what the design patent claims to determine the article of manufacture. I don't think that conclusion is logically entailed by the premise, but I think it's important to be clear about what the premise is. Where the parties are competitors in particular, it doesn't follow that you shouldn't look at what the design patent claims, because that's still telling you something important about what the design is. But this is actually a broadly important argument for two reasons. And first, that design patents are currently granted on known designs applied to new objects. So you can get a design patent on a rubber ducky USB, right? Should that allow you to bring infringement claims against the manufacturers of regular old rubber duckies for the tub? If the answer is no, then the way that we think about novelty and anticipation probably has to be very different. You shouldn't get the design patent just by deciding to put a rubber ducky around a USB core, even though that's novel for USBs. But the second, and perhaps more important in this case implication, is 2D designs, such as the icon on the screen, as in one of the patents in suit, are fully reproduced by many forms of reporting, including newspapers and online news sources. Unlike copyright, patent has no fair use doctrine. So if you don't consider the plaintiff's article at all, it seems to follow that the New York Times infringed the patent when it printed newspapers showing the design patent that Samsung was found to infringe. If that's the case, we have a number of problems, not least of them a free speech one. If you think that we should somehow find a doctrinal way for the New York Times not to infringe, we somehow have to find a way to take what the design patent claims into account in figuring out what articles can infringe it.
Hadn't considered the possibility of the New York Times infringing.
Nor had the New York Times, I suspect.
Well, right, but here's the thing, right? Tell me the doctrinal reason
Yeah.
why that's not true, right?
Well, I think, not that I represent the New York Times, but I think there's a fairly basic statutory argument that a newspaper depicting a picture of an object is not an article of manufacture to which the design has been applied. I mean, you're giving me a skeptical look, Rebecca, but
Well,
I suspect most judges would laugh that theory out of court.
Well, okay, so here's then the question. Apply either Samsung or Apple's test for article of manufacture to the newspaper. I actually don't think you obviously get out of the problem applying either party's test
Well,
without further thought.
but that presupposes a finding of infringement. I mean, let me step back to
Wait,
first.
you said it wasn't infringing because it wasn't an article of manufacture. It reproduces the design 100%.
Not in a way that would be considered infringing under any standard. Because it is not applying the design to an article of manufacture. It's
What's an
depicting it in a
article
photo.
of manufacture?
Well, I think the common understanding of an article of manufacture is something that has been constructed and offered for sale as a product, not an expressive depiction of a product sold or built by somebody else.
I can walk down to the store on the corner and get a copy of the New York Times that sure seems like an article of manufacture. It's printed. It is, we accept 2D designs all the time. Presumably, if I had a design, say a floral design for the back of the chair, and I put it, and someone else put it on, a poster, you'd want that to be infringible.
I guess by the same token, you could look at the problem the reverse way and say that the contents of the screen are also kind of like printed expression in the same way the newspaper is. I guess what this kind of gets to is this is what happens when you allow the different types of intellectual property to start merging with each other. What we're talking about is basically a very copyright-like type of protection here, right? This is a creative work that has some sort of like graphical value in terms of its expression. That's normally the sort of thing that you would protect with copyright, maybe with trademark if it's used to express the origin of goods. The fact that it's now getting into patents creates all of these sorts of weird problems, and it's an unfortunate situation of the current state of intellectual property protection that there is so much overlap among the different types, because having nice clear boundaries between them is actually fairly useful. Unfortunately, what we had recently was a case in the Supreme Court that decided that copyright protection was even more likely to apply to these sorts of things. This was the Star Athletica case. In view of that, it seems like you now have both a very good copyright protection angle, a pretty reasonable trademark angle, and now also a patent angle to protect this sort of thing. And what it means is it makes the doctrinal boundaries, I think, very confused in a lot of situations.
To take on Professor Tushnet's premise a little bit, I think that it honestly points to a relatively more straightforward test that is more aligned with what Samsung has done, precisely to avoid these kinds of problems. Because I think that Samsung would answer that question by saying, well, let's look at what the patent covers, see what it covers. If it's a severable component, it is a component, and you're only going to get the profits attributable to that. So when I look at the New York Times newspaper, it is not that itself might be considered an article of manufacture. It is that Apple's patents don't cover every single application of the 16-icon array anywhere in the world. They cover an article of manufacture, a design for a screen, and either because there's no screen involved in this case, or because the profits are attributable to the New York Times putting the design into its newspaper as compared to the price of the newspaper and all the other content in the newspaper is so minuscule that there's not going to be a practical problem. So I don't think that it's necessarily a problem. I think it becomes a problem the more squishy the test becomes, because if it becomes more subjective and the boundaries between what the patentee has claimed and the real-world application of it, when those lines become blurred, then you get into very serious problems. But again, let's get rid of those problems by clear boundaries, and then we can avoid those kinds of problems.
Well, I think it's important to take a step back. As somebody who actually asserts design patents, enforces them, and defends against claims of infringement of design patents, before you even get to the damages test, there are a lot of intermediary tests that I think protect some of the interests that have been described here. I mean, first of all, a design patent is not done in the abstract. It is only, in theory, you can only get one from the patent office, and in practice, you can only enforce it and sustain an infringement claim if you can prove that the design is novel and is not substantially similar to designs that have come before it or would have been anticipated by what came before it by one who's reasonably skilled in the art. And that's a pretty exacting test. In fact, the test for infringement, the substantial similarity test, is identical to the obviousness or anticipation test. The question is whether a reasonable observer would think they're buying the same item. I mean, that is really the substantial similarity test as described by the Federal Circuit in the Egyptian goddess decision. And that's a pretty high burden to cross. The other thing is,
So I actually want to break in here because I think that gets to an important point, which is when you say the same item, and this is to Professor Tushnet's point as well, is it the same 16 icon grid? Because then I think the paper is selling the same item. There's a 16 icon grid printed. Or do we have to look at what's been disclaimed in the actual patent where, at least for the icon case, you have effectively disclaimed the computer screen or display. There has to be that in that context.
well, there's a difference between the point of novelty that entitles one to a design patent and the article to which the design has been applied. And so I think it's perfectly appropriate to look at the metes and bounds of the patent as one of the important relevant factors in determining what is the article to which the design has been applied. In this case, a screen with a layout of icons that looks like Apple's icon screen, if applied to a similar item, that a court might weigh that factor in favor of a finding that applying that layout of icons to that device is the article, the device becomes the article of manufacture to which the design has been applied. But what we've learned from the Supreme Court's guidance in this case is that the Supreme Court was not endorsing a clear uniform rule like that it wants the courts to sort of wrestle with these kinds of issues. It is important, again, to take a step back at why design patents exist in the first place. To Charles's point, yes, there are many overlapping forms of intellectual property, but the United States does not depart from the rest of the industrialized world in having multiple overlapping intellectual property disciplines. In fact, in most of the rest of the world, there is a separate discipline of industrial design where you can get designs, even over fashion and apparel items, much more easily than you can get them in the United States at a lower standard, and that protect that design in many countries for a longer period of time. And so designers in the United States rely on design patent as a sort of a lesser option, a less protective option to protect their investment and their intellectual property. I mean, companies invest millions and millions of dollars on designers designing lots of things that will appeal to the consuming public, and only a very small percentage of all the designs they invest in actually resonate with the public and allow them to generate profit based on a design. And so when somebody does come up with something that is novel, that is innovative, that resonates with the public, it's important to have a protection that allows them to pursue people who make articles of manufacture that consumers are likely to be confused into believing are generated by the design patent owner. Now, Charles and Rebecca are absolutely right that some of these concepts are hard to distinguish. The likelihood of confusion concept under the Lanham Act, to a layman, is very difficult to explain how that test differs from the substantial similarity test under the Design Patent Act. But these are tests that have been applied for a long period of time, and we haven't seen the kind of parade of horribles of businesses being destroyed because there is an effective Design Patent Act. In fact, the current statute that we are working with was designed in reaction to a Supreme Court case on the issue of damages from design patents, where the courts had said, you have a design patent on the surface of the carpet, you're not entitled to the profits from the entire carpet. You have to apportion the part that was covered by the design patent from the part that is not covered by the design patent. And so Congress specifically reversed that court decision in adopting a different framework. That the remedies.
I'm going to briefly. I think there's an error being made there when you conflate what happened in the carpet cases with apportionment. The carpet cases were about what is the value that design contributes to the article, not about what portion of the article is the appropriate article to look at. It's sort of, the utility analogy is smallest saleable patent practicing unit and then value of the feature to that unit. Here it's what is the article of manufacture, and then we can skip that second test. You get total profits on that second piece. But I think Rebecca wanted to respond to a couple of the things you were saying.
So I just have to respectfully disagree with a couple of Howard's statements about the design patent system. I think the reference to the high standard of novelty is more reflective of utility patent than design patent. If you look at things that come out, like a design patent for a cup holder, which I swear to God, I could not distinguish from any other. It's one of those things that you get at stadiums. It holds 6 at once, and it looks exactly like every one I've ever seen. And I certainly couldn't tell the difference. And that's in part because of lack of resources, in part because, contrary to what you said, the Egyptian goddess eliminated point of novelty as part of the test, and among other things, making it unclear whether the novelty standard and the infringement standard actually converge. I think the issue is...
Well, just on that specific point of novelty was eliminated as the standard by which you eliminate prior art. It was not. It did not eliminate the fact that you needed a new original design.
That's true,
to get
but it doesn't
design.
need to have it doesn't need to be a point of novelty, which actually, in theory, makes total sense, right? It should be possible that a combination of existing elements should make for a new design. I think the point of novelty language, though, has ended up confusing courts, especially the way it got framed in Egyptian Goddess. But the other thing I think that the historical narrative obscures is the rise of partial claiming, which really wasn't a thing until say 50 years or so, and has accelerated a lot. And similarly, we didn't see copyright trolls until about 10 years ago. But now I think no one would deny that they do exist. The causes of action are discovered for complex reasons. Actually, the best thing I've read about this says it's really the result of tort reform. So if you look at who's bringing these cases, including design patent trolling cases, not brought by your firm, right?
Thank you for that.
No, right, so the people who bring the troublesome cases don't show up on these panels in large part, but they're still out there, harassing people like, the small clients, because they can get things that, pay the bills for their firms, not for yours, from the small victims. But it turns out that if you look at those lawyers, they used to do medical malpractice, and now medical malpractice doesn't pay, and so they found other stuff. It's an interesting legal story, but I think the larger point is the fact that something was fit for purpose, 50 years ago, does not mean that if you change a bunch of the legal tests, the rest of the legal tests should stay the same, right?
Yeah, and to build upon that, I think one really important development is partial claiming, but I think Apple Samsung itself presents a sea change in the way we look at design patents, because it's one thing to partially claim the design for a shoe. It's another thing entirely to make a partial claim on a corner of a phone and claim the entirety of the phone. If that's not an incentive for people to enter the patent troll arena and become design patent trolls, I don't know what it is, because you're talking about an amazing amount of money you could earn for something. So to analogize to the way things typically work and the way design cases typically go, I don't know how useful it is anymore in a world in which Apple is claiming, both through, originally it was, well, the product that is sold is the article of manufacture necessarily. The Supreme Court rejects that test necessarily, but we still have to fashion what the test is. But in a world where they want to fashion the test, they can still end up getting the entirety of the profits from that one element of the phone. And I think another thing that's important is to remember is that we're not saying that you will never get the total profits on the article or on the entire product. The entire product may be a single article. It depends upon how it's applied in the product that the defendants applied the design to. I mean, and also if the design is super important, if the patented design is super important, even if it only covers a small portion of the product that's sold, it might still derive the profits for the product. But that's a way in which this still provides a very valuable remedy to people, and it's still I mean, I agree with Howard. It provides you more than pure apportionment that you get in a utility patent case, because even if you claim only a corner of the article, you're still going to get the profits on the entire article, whatever that is defined to be. I think in Samsung's case, I think it's fairly severable to maybe the screen of the phone, the glass of the screen, or the bezel, or the 16-icon array. That gives you a fairly defined thing that you can try and apportion profits to, and that's more than you get in the smallest saleable unit context in utility patents. And I think that's important to remember too, because we don't want to shift the balance too far the other way. We want to protect design, and that gives them a very valuable protection, because it's overly protective to make sure that design is valued. And I think that's a very valuable thing, but we don't want to take it too far and make it grossly excessive in what it gives back to the designer.
So as Rebecca mentioned, it's really interesting to look at kind of how what lawyers see as the interesting new thing for using as a tool of lawsuits. For a long time, that was software patents, right? And why was it software patents? Well, the reason was that the patent office was really bad at examining software patents. They basically, there are a lot of reasons for it. I don't blame the examiners, honestly. I think what happened was that, there just wasn't the right source of prior art, right? Patent examiners were basically looking at patents. There were no patents on software at the time because people were just writing the software, and they weren't looking to the, what software was actually out there tons and tons of software patents issued, over the late 90s, and 10 years later, when those patents are getting close to expiration, they're suddenly very valuable because everybody is using the software that's on those patents. Those patents are really hard to validate because they're 20 years old and all the prior art is lost. That just looked like the way to go if you wanted to start a quick lawsuit campaign. That was cut back not long ago by the Supreme Court's decisions in Bilski and Alice, which basically said that a lot of software patents are going to be invalid on grounds that aren't dependent on that sort of time basis. And so what that means is, okay, so what's another type of patent that is very easy to get? Well, it seems like design patents are very easy to get these days. As Rebecca mentioned, it seems like, again, there's sort of an examination problem going on, that a lot of patents that are coming out of the office, it doesn't seem very hard to find good prior art on them. So, query, why is that happening? It could be for a number of reasons. It could be that the patent office is just not doing a good enough job searching. It could be that they don't have the right prior art resources. It could be that it's just really hard to search for similar designs. And honestly, I think that's probably the most plausible answer to me, that examiners just don't have the equipment or resources to determine whether or not two designs to look at a design and look through a large body of other designs and see which ones look the same very, very quickly. And so what that means is that, I think we're bound to have a fairly large set of patents that can be, scooped up and repurposed to problematic ends. The issue of partial claiming of patents, I think, of design patents is particularly interesting because one of the problems that we saw with software patents was the ability to take, a patent on, potentially a very narrow concept, say, sending, this is an actual example, sending paper files over fax machines to other people's computer systems. So you have that patent that covers a very narrow concept, but then you could go back to the patent office and use techniques called continuation and divisionals, and basically rewrite the text of the patent to cover much more vague sorts of things. So, for example, that patent on sending faxes was turned into a patent on basically transferring files from one place to another, and by this the person claimed that the patent now covered all emails. They clearly didn't invent emails, but by sort of reworking the patent, they were able to say that it started covering something else. This is, you can see the same sort of issue coming up with regard to partial claiming. The patent office is looking into whether or not there's a legal doctrinal hook to prevent that sort of thing. They came up with this very extreme example of, say that I got a design patent on a 500 by 500 grid of black squares, right? And so, so I got a design patent on this grid. Now I selectively dot out some of those squares to produce, an image of Mickey Mouse, right? Do I now have a design patent on Mickey Mouse based on this original patent that I filed of just 500 black squares? Well, theoretically, according to the rules, I am allowed to dash out whichever squares I want, but now doesn't that mean that I can basically claim any design that I want, like, for the rest of time? That doesn't seem right, and the patent office has been, doing some analysis to figure out, is there some sort of legal way of saying that that's not right. I proposed a theory, and there have been a number of theories that have been proposed. But ultimately, what it means is that until somebody figures out a way to do the searching better, or to doctrinally limit the whole the partial claiming situation, we're going to end up with a very large body of patents on very broad designs, and I think that that's going to be a substantial concern for the future in the same way that we've seen with some of these other examples.
Well, can I just jump in to agree with Charles on the software patent? Software patent issue. Yes, software patent issue, and Charles is absolutely right that there was a major problem. That it was easy to take a basic time-tested, well-known idea, say, as applied on a computer, and get it through the patent office. And I'm not just being enthusiastic because my firm argued the CLS Bank case, which was the case that drove the stake in the heart of the overexpansive software patent. But to Rebecca's point, the larger problem of trolling is a larger endemic problem to the use of the legal system as a money-making enterprise. And so what we have seen is that firms that were investing in bringing those kind of software patents have indeed, as that golden goose was killed, they've looked for other targets. And as Rebecca points out, yes, the phenomenon of the copyright troll has arisen, in which there is a whole business of companies that seed the internet with photographs in the hopes that somebody will take those photographs, use them on a website or in a book or in a pamphlet or something, and then sue them for copyright infringement. But there is a fundamental difference between copyright and design patent. Copyright, the Copyright Office does not do any form of comparative relative examination. They just look and make sure that the paperwork seems right and there's no obvious flaws in the copyright, and then they stamp the copyright registered, and it sort of shifts the analysis to the courts. The Patent Office is very different. The Patent Office does a much more thorough searching analysis of prior art and references, and they do searches. Are they perfect? No. Charles is absolutely right. Design is particularly difficult to do searches, although as the technology for visual searches improves, presumably there will be some improvement in the prior art searches that the design patent examining attorneys have available to them. But we're not going to solve in the design patent the problem of entrepreneurial attorneys searching for a quick payday. The question today is, what's the appropriate test?
So that's actually the next question that I wanted to ask, is we've kind of gone through what is important when we look at these claims. What's the right test for article of manufacture? Do you want to start, Carl?
I think Professor Burstein raises some interesting historical reasons for limiting the test, but I think in a lot of ways it's aligned with Samsung's relatively straightforward test, and in a world of there being no perfect test, it makes sense. And I think, and just to summarize it, basically you look at at what's claimed, and you can compare it to some analog in the product that is sold, and if it's it's going to be the component to which that applies. That is absolutely straightforward. It doesn't have any of the subjectivity that is present in Apple's expansive test, and I think it's just very easy to use in the real world, because anybody, it doesn't have to be a court, entrepreneurs and product manufacturers have to do this all the time. I see a patent, or I get a demand letter, and I've got to evaluate my exposure, and they can apply that test in very, very straightforward fashion and get some idea, and obviously not a perfect idea of what their exposure is. And again, I'm not trying to protect copiers, because blatant copying has any number of gives rise to any number of legal problems for copiers and counterfeiters, the least of which is 289 damages. And that still gives design patent holders a very valuable protection, because it gives them sometimes much more than they claimed, even if it's only for a component of the whole.
Rebecca, do you want to distinguish between the New York Times and a screen?
Well, so I think I actually think that's a tough problem either under the Apple or the Samsung test, and Professor Burstein's test solves the New York Times problem only if you also looked more to the claims of the design patent. So it's kind of an independent question. So her her test, which I think has really strong things to recommend, it says, okay, so what kind of unitary thing is the defendant making, right? And the defendant could be making a whole bunch of different things, which it then puts together into a larger product. The New York Times actually isn't really doing that. It's making one thing. It's making the newspaper. So you need some other limit to do the work. And that may involve something that doesn't matter in Samsung, which is sort of limiting the class of goods to which the design patent applies. The thing that interests me actually is the figuring out what the article of manufacture is with respect to the screen, right? The screen layout. I think actually there's a decent case that it's just the physical screen itself, or even the shell, that is the article of manufacture, right? People make those separately. You get they can be sourced from suppliers separately. Those are good dividing lines. What is the article of manufacture for the screen display? And this goes back to, I think, a mistake that was made earlier in the doctrine, where the Federal Circuit allows a design patent on a display of water, right? Once you say that's an article of manufacture, then yeah, sure, the screen layout is too. But I don't know how you figure out what the profit from it is. And maybe that is just to say that that particular screen is the article of manufacture, and maybe there is no profit from it, unlike the situation with the display of water, where the only reason you buy the thing is because it produced this beautiful pattern when you turned it on. I don't know.
So I will punt on giving an actual test, but I'll just say this. I think that, again, this is a situation where it's good to go back to first principles. What promotes the progress of science and useful arts? And I think that the extreme example, the answer to that is obvious. Does a design patent on a rounded corner design confer a benefit to the outer appearance of a phone? Okay, sure. Does it confer a benefit to the speakers? I don't think so. Does it confer a benefit to the cell phone chip? Probably not. And if you think about it, right, to the extent that we're saying that, the profits from those separate components are going, should be wrapped up in the damages award for the design, that's, I think there's a pretty good case that that's, backwards with respect to promoting progress, right? Now, I think if you start saying that, all of those separate components are wrapped up into the total profits, then you're encouraging people to make phones with fewer features so that they don't have to pay out damages for the features that have nothing to do with the design. The screen displays, I think, are somewhat more complicated because of the fact that the screen can display many different things, and I think this is kind of an artifact of the weird way that this law works, which is that it sort of assumes that articles of manufacture embody design patents, and not that they embody design patents at some times and not others. Like that's just that's just a disconnect in the technology, I think, and I'm not sure if there's a good way to deal with that. But ultimately, I think the way to look at it has to be back to first principles and saying, what are we trying to encourage through the award of the design patents? What has the design patent contributed to knowledge that the public is now able to see and that the public has now learned through the disclosure of the patent? And what sorts of other innovations are potentially at risk with an overbroad award?
Like Charles, I also do not have a specific test that I would advocate, but back to first principles, you want to make sure that whatever test is devised does not exponentially increase the complexity of litigation and the cost of litigation for the cases at the extremes. So if there's a cup holder in a car, you don't have to hire a damages expert to go through the automaker's profits to say that it is not the article of manufacture. On the other extreme, if there is a clear fly knit weave design on the side of a shoe that makes anybody want to buy that shoe, you shouldn't have to separate you shouldn't consider the article of manufacture just the side of the shoe. It should be the entire shoe, because under the statute, that's the article to which the design has been applied under the basic statute. So, what is the right multi-factor test? Well, we talked about Professor Burstein's test. We've talked about Apple's proposed test. We've talked about Samsung's proposed test. I'll throw a few others in the hopper that are out there. Perry Seidman, who's sort of the dean of the design patent bar, and 3 other eminent practitioners have released an article where they propose their own proposed test to identify the article of manufacture, which would be the visual contribution of design to the end product, whether the patentee or the infringer sold the proffered article of manufacture on itself, the intent of the infringer, I guess on the theory that if you intend to sell the whole product and make profits on the whole product, that should be an indication that the article of manufacture is in fact the entire product, and the degree of difficulty in calculating profit. If I were a betting man, I suspect courts will coalesce somewhere around the Solicitor General's test, which was the scope of the patented design, the prominence of the design within the product as a whole, whether the design is conceptually distinct from the product as a whole, and the physical relationship between the design and the rest of the product. And there will probably be some variation. The problem with multi-factor tests in general is that courts don't always agree on what they are, which can lead to circuit splits, as we've seen in the trademark world under the nominal fair use test and other places. And I suspect what we are going to head toward is a world where different circuits are going to develop slightly different tests.
How will they do that?
District courts, I think.
District courts, yes, and it'll
Because
work
the
their
federal
way up.
circuit probably isn't going to split.
Oh, that's a fair point.
It happens.
You're right.
It's a different issue.
You're right. I misspoke. I meant the district courts will be developing different ones, and then the federal circuit can split and does split, because oftentimes the federal circuit does not have a majority opinion, even when it goes en banc, and then it becomes a somewhat easier cert petition.
So we're getting towards the end of our time, and I do want to give the audience a chance to ask questions. I have one more question on a break in, on a slightly different topic. I think mentioned this way back when we were first starting, and this is on who has the burden of proving it. Copyright Act has an explicit statement as to how this burden is allocated. The Lanham Act has an explicit statement as to how this burden is allocated. In patents, we don't have that. Is there any reason to take the burden off of the plaintiff in proving what the proper article is?
Is there any reason? Sure. The patent owners have argued vociferously that there are other comparable cases where courts have shifted burdens, where one side, in this case the defendant, is uniquely in possession of the facts of the product. In this case, the economics, the profits, the losses related to the product. That's the argument, and patent owners have generally argued that there should be a comparable design shifting paradigm, as we have seen in the Lanham Act and in the Copyright Act, just judicially imposed rather than statutory.
Having done discovery in several cases, I'm not sure that it's true that there's a real superior knowledge on the part of the defendant.
Yeah, I feel like.
And this is an issue for trial. This is an issue that's going to be determined at the end. It's not something that's a pleading bar, so this sort of superior knowledge doesn't really seem to apply at that point.
Yeah, I think that's right, especially in a world where you can craft discovery to order the other side to do a specific search of its records to give you exactly the data that you want. There is no practical difference between what the defendant alleged infringer has and what the plaintiff has. So I'm not sure that assessment of the burdens really matters. I think what really ought to matter in assessing that burden is, again, the real world consequences of assessing the burden. Because at the end of the day, you're going to ask people who are going to be faced with infringement contentions, some of which may be good, some of which are going to be complete garbage, a lot of which are going to be complete garbage. But they're going to be the ones that have to come up with the experts to do this, I think, the normal allocation and the rule that we apply when we're looking at a statute that doesn't formally assess the burden is on the plaintiff to establish damages, and that carries with it all of the subsidiary legal questions that go with it. In a lot of cases, I think it's not going to matter because you're going to have one party who says that the article manufacturer is X, and the defendant will say, well, I think the article manufacturer is Y. And so you have a joining of the issue, and the burden doesn't really matter. But the burden really does matter when it comes down to arming up to defend against claims and make it much more expensive to face frivolous infringement contingents is a real problem. And I wanted to just briefly address the Perry-Seidman test, because I think whatever faults the Samsung test, the Apple test has, the Seidman test has in spades, because it sort of devolves to any uncertainty just benefits the patent holder, and that is completely backwards from the way we assess burdens in litigation anywhere else in the world. That is, I don't know what the article manufacturer is, I can't tell you, so I get the whole product, even though I claimed just this teeny little thing. Again, when the designer's ultimately in the driver's seat about what their patent claims and what is actually covered by the patent, because again, sometimes they only claim a part of the product because the rest of it isn't patentable. You know, they couldn't get a patent on the rest of it. Sometimes it's strategic to get a partial patent. That is, you get it, you know, like Apple did, you get it on every different component of the phone so that you can assert it in different ways and maximize your recovery. Sometimes you just couldn't get the whole thing. So you're allowing them to capture the entire product when they couldn't get a design patent on the whole product, just for this kind of squishy, I don't know, so give it to the designer, and there's no real legal foundation for that.
Rebecca or Charles, before I open it up to questions from the audience.
I was just going to say that this is my formalism talking, but when we're talking about something like burden shifting, we have to say compared to what, right? So there must be something that the plaintiff has to prove before we start burden shifting. And since article of manufacture is a different part of the claim than, say, infringement, I would say by default the burden would be on the plaintiff. Otherwise, we don't even know what it is that we're talking about. But I also agree that as a litigation matter, usually the issue will be joined by the parties. But when we're talking about things that ordinary jurors and even judges are not going to have much experience with, the burden can matter a lot, right? Because it's not the case that people ordinarily consider like, well, what are the parts of a phone, right? It's something where when you say, tie goes to the runner, it matters very much who the runner is.
I have thoughts on this, but would rather hear audience questions.
So, does anyone have any questions? We've been very thorough. Well, in that case, yeah.
So I'll ask a question of Carl, two if you will. First, you indicated that Apple was sort of stacking the profits. Could you clarify, what profits they're actually seeking? Because I'm not sure if they are or not.
So number one, we sort of set the reset button, so we don't entirely know. And the parties' submissions on remand don't go into detail as to exactly what profits they ought to get on which models, because and the findings in the original trial are almost useless, because like you're talking about, I think 8 or 9 different models of phone, and you got the different, like there's a grid in the jury charge. It's crazy to try and assess exactly what they were claiming.
So it said, maybe can we state the law of profit for, so you can't double recover, right? So could you talk about that?
So there's no more than twice recovery of, let's see, I don't have the statute in front of me, but it's like no more than twice recovery of the total profit. So you can get more than one recovery, and I don't exactly know how they're planning to parse it, but they do plan on saying that the article as to each of the patents is the entire phone. So they're at least setting up 3 different ways of making sure they get the total profit, and then they may try and go up to double profit. The larger problem, I think, is in, what if it was a different defendant? I mean, a different plaintiff, like, what if one company owns the bevel, the bezel, one company owns the patent on the screen, and another company owns the 16 icon array? That could be a triple profit award. That means not only do we lose everything they made on the phone, they lose it 3 times.
I don't represent Apple in the case, so I can't speak to what Apple is seeking or not seeking. So I don't know, but I would be very surprised if what we're talking about is duplicative double or treble damages. There's a familiar concept in IP law and statutorily provided in the Lanham Act that you can get up to treble damages to the extent equity allows. But it is very much, that remedy is very much designed to compensate a plaintiff who is undercompensated by the direct profits of the plaintiff. To Carl's point, if there were multiple defendants, there are also analogs in IP law that might be useful. Certainly, if you are a joint and several, if you are a contributory or infringer in the copyright or the trademark context, the plaintiff is not entitled to get the full judgment against the direct infringer as well as the contributory infringer. The concept is joint and several liability. And then if one defendant ends up paying all of the plaintiff's damage award, the other defendant, who is also partially responsible, can seek contribution from the defendant that didn't pay. And I would assume that would be the paradigm that would apply.
But those are going to be situations that pertain to a shared act of infringement, like the retailer might infringe for the same basic, act of infringement that the manufacturer and the designer did, and they'll apportion the damages between them. I don't think it pertains to different claims under different patents, because it's a completely different world. I think it's another, I don't know, there may have to be some kind of new rule created, but they could be in different district courts all over the country. They could be happening at the same time, and the single recovery rule is as to a single act of infringement. It isn't as to different acts of infringement.
If I were the defendant defending against a claim of multiple design patents on the same product, I think I'd simply argue, if I was wiped out in the first judgment, that was my profit, it's gone. The total profit is not gross profits. It's generally considered to be net profits.
So to Carl's point, there's a pretty good law that says that each patent is a separate cause of action. So you wouldn't have the sort of like contribution theory. My guess is that most judges would go with with our theory of look, if your patents went out once, or if your profits went out once, they can't go out to somebody else again. But that's kind of weird, right? Because what it means is, whoever gets the courthouse first gets all the profits, and then the second person and the third person and the fourth person get nothing. That's just a weird feature of the way that this law works, and I think it's the result of this sort of unexpected situation. But the original intent of design patents was to cover entire designs of entire products, and then it made a lot of sense to say, the one person who has a design patent on the product gets all the profits. But now with partial claiming and continuation practice and such, because of the fact that the patent gets split into multiple parts, you end up with this sort of weird situation where potentially there could be a race to the courthouse over.
I agree with it's weird, but I'm not sure it's more arbitrary than one defendant has a big award against it because it had products that sold, the other defendant doesn't have products that sold.
Well, nothing prevents you from seeking a non-total profits remedy.
Right, that's true.
You could seek a reasonable royalty against the defendant who had products
That's absolutely
sold.
right.
You have those options. You have an additional option of total profits, which is usually going to be preferable. Do we have other questions from the audience? Or if not, there's something I'll actually follow up on here, which is the notion that if you do have these multiple patents, each claiming a portion, and each one drives the whole design, and each one is entitled to recover the total profits, does that affect what we think about what's patently distinct? If all of these are crucial to the whole design, are they really patentably distinct from one another? I don't know if you want to.
Right, so, yeah, I think this is just another way of reframing the serious problem we have with partial claiming, right? And if I could go back to the drawing board, I might say, you know, Egyptian goddess had a point, but the point only makes sense if you have to claim the whole thing. And then it makes total sense that there's going to be lots of stuff in the design that isn't in fact novel. Then we need to know what it is.
I don't know if that makes it easier or harder for Apple to say we have multiple overlapping patents in this case, so these phones we get the whole profits, or whether it creates a theoretical issue that undermines the test.
If we don't have any other questions from the audience. Oh, in the back.
Professor Tushnet, I noticed you raised your eyebrows at a couple of the factors of the statement test, particularly the intent one, so I wanted to ask you what role you felt intent should play, if any, in defining the article of manufacture.
Yeah, very little or none. I mean, intent is always a dicey factor because it's very manipulable, and I think almost anything is less manipulable. But also, I mean, you can always slice intent into different parts, right? So, for example, if you intentionally have a supplier manufacture a chip separately, right? Does that mean that you intended them to be different articles of manufacture? I mean, it seems sort of pointless, regardless of what the other factors that you identify.
The only thing I would add to that, and I don't disagree, is that the real question, if you're going to consider intent, is intent to do what? The definition of intent to make money, or is the intent to create a copy of the entire product. And if that's the way the test is framed, it seems a little fairer, but much more difficult to imagine there's going to be proof of that.
Well, and I think it gets into another problem. I agree with you, and when having read Apple's submission, I'm not entirely sure what they mean by intent either, because they're a little internally inconsistent. But if it is intent to copy, there's an entirely different aspect of the Patent Act that covers when you try and copy something, and you can get up to treble damages for doing so. So I think a problem with the Seidman test, and I think it also gets into the Apple test, because Apple's also includes an element of intent, is, what's distinct about 289 and what we can't borrow concepts from other areas of patent law, because you're essentially double punishing for intent. If you did willfully infringe, there's a remedy for that. It's not 289, because 289 never mentions anybody's intent or knowledge or any scienter requirement at all.
And again, partial claiming interacts with this. Right? The more partial claiming you have, the more difficult tests like intent become to apply, right? So, and this goes to the infringement question that Howard was talking about, that yes, the standard is, would you likely confuse one for the other? But as long as we're saying would you confuse this line of the phone with this line of the phone that otherwise looks completely different, it's a weird question to be asking, and one that's difficult for any fact finder to answer in an objective way.
Yeah, well, as a practical matter, what would happen is you would look at the design that was appended to the patent, compare it to the product, and then it is, unfortunately, in the eye of the beholder as to whether the product would be substantially similar enough as a whole to believe that a reasonable observer would determine that one product is the other.
Well, except, so now you've moved seamlessly back to the product, the plaintiff's product, right? So there is actually no way to if you ever compare a partial claim to the product, no, they're not going to look alike, because one's a line and one's a phone, right? So you have to then fill in those lines in some way. Or you have to say, I'm going to compare the line in the design to the line in the phone, right? And which is not a consumer concept. It's a much more abstract concept.
Jimmy Hoover, Law 360. You guys talked a lot about the fact that a lot of weak design patents have been issuing over the last few years. And I was wondering, 5 years after the PTAB, if you think that that administrative body's had any remedying effect on that issue.
I don't think there have been that many design patent challenges in that body. Probably this is largely because there are bigger fish to fry at this point. The problem with patents is that everything gets delayed by about a decade. They're not going to start showing up in the PTAB until they start being, an actual, force of litigation, and that's not going to happen until there's been a certain amount of time for them to be out there on the market, to change hands a couple times, go up to auction. So my recollection is that there's like a Caterpillar case that has gone to the PTAB. I'm not totally sure where that is, but as kind of a general matter, it hasn't. That hasn't been the main event. It'll be interesting to see whether or not that does become the case. In about a decade.
I'm not aware of any empirical research that would indicate either that the design patents issued recently are getting worse or better, or whether the PTAB has been effective in, or has had any effect on that. Others may be aware of more detailed research on that.
I don't really want to comment because I just signed a brief saying that the PTAB is unconstitutionally constituted. So I'm not going to get into that.
Yeah, I'm not aware of a significant impact from PTAB because I don't think there have been a few design patent challenges, but not many.
Kind of in a similar vein, are any of you aware of any data or evidence that there's been an uptick in design patent cases?
So I think the answer is yes, and probably the best data come from Lex Machina, which is a Stanford spin-off, which collects
Smart Lumley's, right?
Yeah, it collects data about filings, and so I would refer you to there because the numbers there will be much better than any I could produce. But I think yes, there's a pretty clear reaction.
To the Apple v. Samsung?
I would say it's Apple v. Samsung. And in fact, Sarah Burstein has actually tracked an uptick in people claiming damages under 289, even for utility patents. So, just awareness of it has increased enough that you're seeing more, even where you clearly shouldn't.
There is some anecdotal evidence of design patent portfolios being assembled. I don't know if there's any reliable statistics on that being done, but by ostensibly assertion entities. But it's hard to really put any uptick or downtick in that. They're just recognizing. I think that 289 kind of lay dormant for a long time, and certainly there's a recognition that it exists, in a way that it didn't before.
Yeah, I was just going to interject. I think one point is that you don't necessarily need an uptick in design patenting to have an uptick in assertion. As people become more aware that, this is actually an option that I can succeed with, you'll see people following on the same issue you saw with software patent trolls, with copyright trolls. It wasn't that those things didn't exist. For software patents, for a while they didn't, but it wasn't that they didn't exist, it was that we needed to have...
Although filings have also doubled in 10 years. So there's definitely...
Which is significantly more than we've seen in the utility context. So it's not just the general growth.
Well, there are other empirical reasons for the uptick in design patent applications, not the least of which is that the Patent Office has gotten very much better about resolving them on a shorter time frame. The time frame used to be up to 18 months. It's now down to, I guess, I don't know what the latest date is, 6 months, something like that. And so when you're talking about designs and changing tastes, you have a better return on a design patent you can get in 6 months than you can get on a design patent that takes you, up to 2 years to get.
Yeah, although I think the distribution is not, fashion designs, right? So the fact that entities like Caterpillar, which really don't depend on design to sell their products are also going, I mean, I think that the uptick is in everything rather than products we conventionally think of as being sold by their design. So,
Any other questions? Any last thoughts?
Yes,
sir.
Sorry,
Just
Mr.
one more question,
Yeah.
since, we're all here, right? So, I think it was Charles, you mentioned the Federal Circuit being kind of out of step with the Supreme Court. And I've heard that narrative repeated a lot, and I just wanted to see if anyone wanted to see if it was deserved, or maybe a little bit overblown, or, the reason.
I think there are kind of two brass tacks basic reasons. I mean, and every case is individual, but, at the end of the day, the Supreme Court's, right because it's final, not final because it's right. And the Federal Circuit and the Supreme Court just have a different basic conception of the fundamental underpinnings of what a patent ought to be and who it protects and the balance of interests in between them. So they tend to, they tend to get at loggerheads because of a basic fundamental difference. Sometimes, and that's the second element, sometimes that's deserved, because I think that for a long time the Federal Circuit did its work without a lot of oversight. And, I think sometimes their subject matter expertise led them to be kind of blind to the larger body of law that their patent law had to kind of fit into. And so there has been a project by the Supreme Court to kind of like bring it into the boundaries of the rest of law, and not to make patents the outlier in everything. And I think that is, in a way, deserved. But I also don't think it's not because the Federal Circuit judges are terrible judges. It's because they have a different focus, I think, at the end of the day.
I agree, and I think that some of this is just the necessary interplay between having one federal court of appeals that is a real subject matter specialist that focuses on particular areas of law, and a court that tries to keep the national perspective in mind.
I mean, I think in addition to those points, which are both right, the Federal Circuit has no sibling courts. It decides all the patent cases, and as a result, it doesn't enjoy some of the discourse among the circuit courts that tends to help with the sort of deliberative process. And so really, the only other body that can come in and step in and say, hey, something's wrong, is the Supreme Court. For a long time, the Supreme Court didn't do that. For I think the first 15 years or so of the Federal Circuit's existence, no patent cases went up to the Supreme Court. And some of the academic research that I've heard about coming down the pipeline, they looked at this and said, as a result, the Federal Circuit just kind of took themselves to be immune to review, and so they just kind of did whatever they wanted. At this point now, they're kind of starting to pay the price for that. But I think that it's so. I think that there's sort of the structural issue. There's sort of a historical aspect to it, and then there's also, as Howard mentioned, the sense that the Federal Circuit has been very, very focused on patent interests. The Supreme Court having to look to much larger concerns has often tried to say patent law is not all that different from other sorts of law. You shouldn't really be making up special rules for it.
I have nothing else.
Well, do any of you have any last things you'd like to say on this topic, or? Pretty good, I think. Thank you all for coming. Thank you to the panelists for what has been an entertaining conversation. And
Thank you, Josh.
Yes. Thank you.